Hello, my name is Elizabeth Broccoli, and I'm the director of the Pre-Law Institute here at John Jay College. On behalf of the Future of Public Safety Initiative, the Pre-Law Institute, and the Office of External Affairs, it is my honor to welcome you to today's panel discussion about guns, survivors of domestic violence, and a current case that is pending before the U.S. Supreme Court, U.S. versus Rahimi. This afternoon, we are joined by a panel of experts who will discuss U.S. versus Rahimi and its potential implications. For the first 45 minutes or so, we will hear from the panelists, and then we will invite your questions in the chat, time permitting, at about 2:30. I will serve as the facilitator of the conversation, and I am so pleased to be joined by two of our John Jay students and pre-law scholars, Giovanni Love and Michelle McLean, who will assist me with asking questions of the panelists. So let's get started. I am thrilled to introduce you to our four panelists today. Jennifer Becker is an attorney and the director of the National Center on Gun Violence and Relationships at Battered Women's Justice Project and the project director of the National Resource Center on Domestic Violence and Firearms. Welcome, Jennifer. Maxwell Mack is associate professor of political science here at John Jay, and he's chair of our political science department. He has published and taught on the role of the Supreme Court and judicial politics. Welcome, Max. Ian Mielheiser is senior correspondent at Vox, who focuses on the Supreme Court and the Constitution. He has written two books that discuss how the Supreme Court affects our nation. Injustices, the Supreme Court's history of comforting the comfortable and afflicting the afflicted, and The Agenda, how a Republican Supreme Court is reshaping America. Jennifer Weindel is the project director of the National Center on Improving Community Supervision Responses at the Battered Women's Justice Project. Thank you to all of our panelists and welcome. Before we get to the case, let's discuss domestic violence in the United States. What is the prevalence of domestic violence in the United States? What is the incidence of abuse? Ms. Becker and Ms. Weindel, will you take this question?
Sure. I'll start it off, and Jen Weindel is my colleague, so we'll pass it back and forth to each other. But I think when you're talking about prevalence of domestic violence, you have to start with the recognition that intimate partner violence is a range of behaviors and conduct. Physical, sexual, emotional, things like coercive control, financial abuse, technology-related abuse. And we don't always have, neat prevalence statistics when you consider the full range. But what we do know is approximately 1 in 5 women and 1 in 7 men report having been subjected to what they categorize as severe intimate partner violence in their lifetime. And that amounts to about 20 people in the United States every minute are subjected to some form of physical abuse by a partner. We see higher rates in particular communities, folks in the LGBTQ community, Latina women, Black women, Asian women, women in Alaska Native and American Indian communities report higher rates of intimate partner violence. And when we're talking about the intersection of domestic violence and gun violence, we know that according to a survey by the National Domestic Violence Hotline several years ago, 67% of folks who had contacted the hotline and completed the survey reported that they believed their partner was capable of killing them. We also have some data that about 1 million women report having been shot at or shot by an intimate partner. 4.5 million women report having been threatened with a gun. And a good sort of foundational study on this intersection demonstrates that when a gun is present in a domestic violence situation, the likelihood that the woman will be killed goes up by 500%. And Jen Weindel, I don't know if you want to add anything to that.
No, I was going to bridge into, those were some really helpful stats and context. I was going to bridge into part of what our discussion is, that intersection of gun violence and intimate partner relationships. So one of the questions that was bridged was, how often is it reported or there's a use of a firearm in a domestic violence incident. And I'm going to give you some statistics on that, but I do want to say that it's an underreported number because sometimes survivors don't think that the abuser leaving the gun on the bedside table, let him know what may or may not be in their future, or carrying it down by their side or placing it at their head but not pulling the trigger and things like that. I teach at a police academy, so I have to give them a lot of context that perhaps the survivor's not calling this time because they didn't fire a round or they didn't, touch them with the firearm, but they have access to it and they know that it's there, and that's a lingering use of control in its own certain way of violence. So for actual statistics that are out there, my colleague, Ms. Becker, already outlined that women are more likely to be the victims or survivors in these scenarios. And 80% of intimate partner firearm deaths are women. And on average, every month, there's 70 women that are killed by firearms intimate partner violence, which is a terrifying statistic, right? And then to couple with that, the unnumber of statistics of how many times a firearm has been threatened in that intimate partner relationship or at their place of work or with other family members, which leads me to, of the murder-suicide rates that you see in media or that you hear in that ticker tape or see in that ticker tape across the TV, 73% of those murder-suicide rates were an intimate partner violence relationship. And what's been increasing in the research of mass shootings, which occur for 4 or more people, so that may be your workplace violence or home violence where stalker or abuser or former partner or current partner of someone follows them to another place and they end up harming other people in the community, other public safety officials, as well as shooting their victim. So that reaches as much as 59% of mass shootings are linked to domestic violence. So gun violence is prevalent, or the threat of future gun violence is prevalent in intimate partner relationships.
Thank you. Let's turn to the case now. Ms. Becker, could you tell us more about the specific question that the U.S. Supreme Court is considering in U.S. versus Rahimi?
Yeah, absolutely. And first, I just sort of closing up the discussion we were just having, will add that we recognize and build into our work that people of all genders and all identities are victims of domestic violence. The research that we have available in terms of prevalence is imperfect, and that it very often, uses sort of heteronormative assumptions about relationships. And so that's why the data leans heavily on women as victims. But yes, in terms of the case, the federal law has 9 sort of categories or conditions of which people become prohibited from possessing or purchasing firearms and ammunition. 2 of those prohibitions are related to domestic violence. So one prohibits folks who are subject to qualified domestic violence protection orders or restraining orders. And the other prohibits people who are convicted of certain domestic violence misdemeanors. And then there's a general prohibition for folks who have been convicted of any felony. So that can, of course, also be domestic violence related. In the Rahimi case, the Supreme Court is considering the prohibition that relates to domestic violence protection orders. So a qualifying protection order has to meet conditions set out in the statute. The person subject to it, for it to be a qualifying order, has to have had notice, the opportunity to participate in a hearing, and the prohibition on having a firearm is only during the time that that protection order is in effect. That law has been in effect since 1994, but more recent Supreme Court precedent, in particular a case called Bruin, has sort of opened up the ability for this challenge to move forward. So Second Amendment jurisprudence, particularly after the Bruin case, which said that a restriction on the Second Amendment right to bear arms has to be rooted in history and tradition within the United States. And so, so in this case, the Supreme Court is only looking at that federal law that relates to a prohibition for qualified domestic violence protection orders. There are also many states that have a mirroring state law, but the court is not considering every state statute. Of course, those could be impacted, but the court is only looking at the constitutional validity of this one firearm prohibitor.
Mr. Millhiser, could you give us some background on how U.S. versus Rahimi made its way up to the U.S. Supreme Court? Where did it originate?
Sure. So, I mean, the short answer to that question is just there was a criminal defendant who was charged with violating the statute, and he appealed on the theory that the statute was unconstitutional. But like how we got there is a story that is as much a political story as it is a legal story. So Zaki Rahimi, the defendant in this case, is a person that no sensible society would allow to be armed. This gentleman has been accused of 6 different shooting crimes. And by shooting crimes, I mean not just a crime where he used a firearm, but a crime where he actually discharged a bullet from the gun. You know, in one case, he was beating his girlfriend, who is also, or I believe his ex-girlfriend now, who is, also the mother of his child, in a parking lot. And a witness walked by, saw him doing this, and he pulled out a gun and started firing at the witness. So no sensible society would allow this particular gentleman to be armed. He was eventually found with a gun while he was subject to a restraining order, and so he was charged with violating that federal statute. He lost in the trial court and then brought his case to the U.S. Court of Appeals for the Fifth Circuit. And I don't know what folks here know about the U.S. Court of Appeals for the Fifth Circuit. The Fifth Circuit is not a place you go if you want to see law happen. The Fifth Circuit is dominated by MAGA-aligned judges who have been engaging in a whole lot of sabotage of U.S. law lately. And they struck down this particular law. They declared it was unconstitutional on its face, which means that there are no circumstances whatsoever where someone can be prosecuted for violating the law, forbidding people with domestic violence restraining orders from having guns. That was then appealed to the Supreme Court. So that's the simple version of how we got there. The longer version is that Donald Trump won the 2016 election and replaced 1/3 of the justices. And one of the consequences of that was that we got this decision called Bruen, New York State Rifle and Pistol Association v. Bruen. And Bruen has 2 prongs. First of all, it says that all current gun laws must be, quote, consistent with this nation's historical tradition of firearm regulation. That means that courts have to look to an historical analog. And so if you have a modern law and there isn't a similar law there's a bit of a debate of whether it has to be a similar from 1790 or is from 1867. But anyway, you have to find a similar historical law. And then on top of that, the second prong of Bruen is that there is a presumption that gun laws are unconstitutional. So if you go through the historical record, you don't find any gun laws that are or it's just indeterminate. It's unclear whether there was a similar law. The government loses. There's an especially strong presumption of unconstitutionality if the current law that's being defended involves a, quote, general societal problem that has existed since the 18th century. Now, domestic violence is an example of a general society problem that existed in the 18th century, but there were not, modern anti-domestic violence laws. Some states had laws where if there was a spouse who was being abused, they could go to a court and they could get an order requiring the spouse to put some money up that they would then forfeit if they committed domestic violence, but there was nothing resembling the modern web of anti-domestic violence laws. And there was certainly nothing like this particular law. So if you take Bruen seriously, what the Fifth Circuit said in Rahimi was correctly decided. The problem here is that the Supreme Court came up with this Bruen framework that makes absolutely no sense. I know I've been talking for a while, but I just want to say 2 quick things about why this law why Bruen makes absolutely no sense. The machine gun was invented in 1884. I've already said domestic violence laws like we have now didn't exist back then. You know what else didn't exist back then? Police forces. The modern police force, I mean, there were watches, there were slave patrols, there were some things that historians have tied to the modern police force, but the modern professional police force, where an organized band of professional law enforcement officers who are employed by the state and organized in a hierarchy, that was first created in 1828 in London. I believe the first US police force emerged in Boston in the 1830s. So there are tons of gun laws that exist now that didn't exist way back in the day because we didn't have the state capacity way back in the day to have any kind of enforcement of gun laws. So the Supreme Court has created this framework that basically makes it impossible for modern day gun laws to exist. I think they have realized the folly of what they have done in this Rahimi case. And the question now is how much of Bruin is going to get rolled back.
Dr. Mack, the Supreme Court heard oral arguments
Mhm.
from Rahimi last fall, and we are waiting for a decision. Can you tell us how the makeup of the U.S. Supreme Court influences its rulings?
Well, you can see this. Well, thanks for the question. You can see this happening in multiple iterations, right? What Ian was mentioning about how Bruin holds is you have justices that supported that decision. And it's the craziest thing because we'll go back a little bit. This idea of history and traditions can be really problematic because it holds us to 1790s thinking, right? If you're looking for an analog of 1790s thinking, it's impossible to do. And anytime you mention the word history and tradition in jurisprudence, you're definitely targeting and saying the law doesn't cover probably women, persons of color, anybody who's been marginalized whatsoever. And so in that kind of conversation, you now have to think about where the justices stand and where they go. So if we're talking about ideology, right, we can pretty much guess that three of the justices who are the liberal justices on the court, Sotomayor, right, Sotomayor Sotomayor, Elena Kagan, and Ketanji Brown Jackson, right, they're going to decide in a liberal fashion, right? So they're going to say that the government has every right to do this. They can regulate that Section 922, which is the law at issue here, right, is actually constitutional. And the government has every right to regulate this idea that someone who's convicted of a domestic violence charge or under a protective order, they have every right to regulate this, and this law is constitutional. So let's just assume that. We also know that, right, Sonia Sotomayor wrote a decision in 2014 in US v. Castleman where she cited the congressional record that pretty much, in that congressional record, they said the only difference between a battered woman and a dead woman is a gun, right? And so there's clearly support that Sonia Sotomayor and Elena Kagan, who joined her in that decision, will clearly support the government's position in this argument. So it leaves the kind of six conservatives that are on the court, right? So you have Chief Justice John Roberts, you have Brett Kavanaugh, who's a Trump nominee, you have Amy Coney Barrett, who's another Trump nominee, Neil Gorsuch, another Trump nominee, so he got a third of the court, right, as Ian mentioned. And then you've got the two older ones, Samuel Alito, right, who's a Bush Part 2 nominee or Bush 43, and then you have Clarence Thomas, who's a Bush Part 1 or Bush 41 kind of nominee. So you have six conservatives on the court that if they voted ideologically, they would support, right, Rahimi's claim that the government has no ability to regulate in this one and that Section 922 is completely unconstitutional. But I don't think that's the case because Rahimi is not the factual circumstances that you could decide upon, that the ridiculousness of this dangerous person, if the court said, hey, Rahimi, right, like this law is unconstitutional, you would allow someone like Rahimi to walk free of a federal charge. And that would look pretty bad on the court. But given how the courts behaved recently in public opinion, you could probably see at least two of them not care, which would be Samuel Alito and Clarence Thomas, right? You probably could suggest that Neil Gorsuch would side with them. So it really comes down to how John Roberts, Amy Coney Barrett, and Brett Kavanaugh will decide this case. And really, you could see it being something simple is that the government has every ability to regulate someone who's dangerous and prevent them from owning a gun, which everyone in their right mind, right, during oral arguments suggested that the definition of dangerous and Rahimi falls within that. But the question is, how about the margins? We need to look around Rahimi and say, what happens when the definition of dangerous or law-abiding or responsible is unclear, right? That's what's really weighing it. Yes, the political context of Rahimi says this guy's ridiculous, but the court's going to kind of avoid that and say, well, what happens about everyone else? Let's try and avoid Rahimi a little bit. But that can't be the case. And so you're going to probably find Roberts, Amy Coney Barrett, and Brett Kavanaugh finding some way in some combination of the three or all three of them, saying that the government has always had a tradition of limiting firearms of those who they deemed dangerous, whether they were convicted of that danger or not. So the classic example that if you look back through the text is that British loyalists were not allowed to own guns after the war, whether they were actually actively fighting against the government or the United States at that time, right? Or not. If you were deemed a loyalist, you were not allowed to own a gun. They were deemed dangerous in that sense. So you can see some combination. So in other words, ideology drives apart, but there is this group in there that says we're not going to adhere, may not adhere directly towards Bruin. And we may find some room to let the government do this. You can make the argument that Bruin is incredibly problematic. You can make the argument that Bruin is the question at issue here and whether Bruin should survive this case. But I'm more likely to lean that they're going to avoid Bruin altogether and defer to this idea that, hey, the government has always had this ability to regulate, and we're going to let this stand.
Dr. Mack, when do you expect a decision will be released?
This really depends on how it rolls, but generally decisions, they hold them back. They've got other pressing issues like a Trump lawsuit or multiple Trump lawsuits. So this will probably be around June, right? You're going to get a decision really at the end of it, given the saliency of the case.
Thank you. Mr. Millhiser, could you tell us what some of the consequences would be if the Supreme Court decides to overturn the current law that disarms abusers? Would states then have the right to disarm abusers by enacting new statutes? And if so, what do you think the implications would be in New York State specifically?
I mean, it would be catastrophic. I mean, again, this is what is called a facial challenge, which means that if the court strikes down this law, they aren't just saying that like it was unconstitutional as applied to this one individual. They're saying that there is no set of circumstances under which this ban on domestic, people with domestic violence restraining orders having a firearm can ever be enforced against anyone. And if that's the holding of the Supreme Court, the states can't do it either, because the Supreme Court binds all 50 states. And and I'll add one other thing, which is that it would be, if they're going to strike down this law, if they're going to say that wife beaters have a constitutional right to have firearms, no gun law is safe. I mean, like, this is the gun law that I think every sensible person in the universe would think this law should exist. And so if they're going to strike this thing down, God knows what else they're coming for. Now, that said, I don't think that outcome is very likely. I think what is probably going to happen. So in the Bruin case that I mentioned earlier, and here let me give a little bit of history. So the Second Amendment wasn't a factor at all in U.S. jurisprudence until 2008. In 2008, until 2008, they took the first words of the Second Amendment, the ones about the militia, very seriously, and the Second Amendment was not understood to protect an individual right to own guns. That changed in 2008 with a case called Heller. Of the first time in American history, the Supreme Court said that individuals can bring Second Amendment suits, and there was a compromise in Heller. Justice Kennedy, who was kind of a moderate Republican, didn't want to sign on to a decision that would lead to every gun law, huge swaths of gun laws being struck down. And so he insisted that a section be added that said, of course, there's still some gun laws that will still allow, bans on gun ownership by people with felony convictions or serious mental illnesses, bans on what are called dangerous and unusual weapons, bans on guns in sensitive places, whatever sensitive places. And like this list of things that Kennedy wanted to keep, that had nothing to do with the Constitution, had nothing to do with history, anything like that. These are just things that Anthony Kennedy thought were good ideas. And flash forward to Bruin, which was decided in 2022, Brett Kavanaugh writes a concurrence joined by Chief Justice Roberts, which essentially says, I still believe in this compromise that Tony Kennedy reached, and like quoted at length from that section of the Heller opinion and said all of these categorical exemptions are still good, and I might be willing to create other categorical exemptions. So I think what the law is likely to be after Rahimi is decided is, I mean, they'll still require lawyers to go through the stupid exercise of doing a lot of historical research and like putting a bunch of facts about what the law looked like in 1791. But what the law is actually going to be is it's going to be the law of Brett. Whatever Brett thinks is a good is a good gun law. And I mean, it may not just be Brett, but you can also win if you get the 3 liberals plus John and Amy. But that's what it's going to be. It is going to be a shift from the unworkable historical framework laid out in Bruin to something like the Kennedy Compromise that Kavanaugh has since endorsed, which basically says that if you got 5 justices who think that this law is a good idea, then it'll stand.
Thank you. Turning back.
Elizabeth,
Sorry, go
can I
ahead.
jump in
Yes,
real quick?
Please, please.
So the implications, right, of this decision, let's say they do strike down section 922, right? It's going to put domestic partners, right, in danger of violence, right? It'll go unchecked. But the one that was actually mentioned in oral arguments is the fact that the other allegory to this is the ability to do gun checks and background checks before purchasing a gun. And there's been something like 77,000 purchase of guns who have been prevented because of a background check based on domestic violence, that they've been prevented. These are the things that are going to happen and proliferate if it hasn't been allowed, if they do allow this to go through and they strike down the government's ability to regulate domestic violence, right? So the challenge here and the real legal question here is the most interesting is who determines what's dangerous, right? Is it the current government that makes the laws, or is it 1791's thinking, right? If they go anywhere near that. And these are the problems that we're going to run into. And these are the societal problems. These are the questions that we must encounter is who defines what? And then that has massive impacts on your daily life.
Thank you. So Dr. Mack, you brought up survivors of domestic violence, and I'm wondering, Ms. Wendell and Ms. Becker, if you could tell us what are the legal strategies currently in place to protect survivors of domestic violence? We know that the Supreme Court has been much more likely to restrict the government's ability to limit gun violence and not particularly supportive of the rights of domestic violence survivors. Is there a path for the court to expand protections for domestic violence survivors?
Well, I mean, in terms of strategies on behalf of individual survivors, it is still to utilize the domestic violence restraining order processes that are available in states and localities. Domestic violence protection orders are an incredibly important tool for safety. They're flexible. They can be responsive to not just danger from the risk of gun violence, but to a full range of things. They can provide for safety regarding custody of shared children, child support, marital support, obviously a full range of physical safety. So, one of our concerns is sort of the misunderstanding about what domestic violence protection orders are and do and what the process looks like that has sort of gotten rolled up in this question as the Supreme Court considers the validity of this prohibition, which is specific to protection orders. I think for those of us that work in this field, I don't know that any of us have been looking or expecting there to be an expansion of protections. I think what we have focused on is maintaining the protections that are available now, right?
Maintaining and protecting, exactly.
So I agree with all the comments that have been made already that, from the oral argument, it seems likely and hopefully so that the prohibition will be upheld. How it is upheld, it can be, when the justices are reaching, I think, further to what Dr. Mack and Mr. Millhiser were talking about the makeup of the court, to come to a controlling decision, there's likely going to need to be compromise. And so what happens to make that compromise could make the landscape fairly complex. And so hopefully it is more straightforward. In terms of what expanding protections might look like through this decision, there is Supreme Court precedent that speaks, at least in dicta and conversation and argument in decisions, about this dangerous intersection. So there is a case that the Supreme Court specifically acknowledged that firearms and domestic violence are dangerous combination. Dr. Mack, I think, referenced the Castleman decision where the court expressly, accepts the understanding that domestic violence encompasses behavior that might not look sort of obviously violent in a non-domestic violence context, but recognizing that this is a range of behaviors. And so if this decision also wove in those understandings, that could be an important expansion for, further litigation and protections down the road. So, and if the decision could actually sort of rehabilitate some of the misunderstanding about what protection orders look like in domestic violence, right? There is process they're afforded to parties during these proceedings, right? And so kind of rehabbing some of that, there seems to be some misunderstanding, even in oral argument, about what it really looks like. And these are really critical tools that we want survivors to be using. So I think that's what we're looking for when we think about how could there be more protection through the Rahimi case itself, other than just upholding and keeping the status quo. Jen, would you add anything to that?
No, I think you said that all very eloquently. Thank you.
Thank you.
How long are domestic violence protective orders usually in place? Is there a time limit on it? Is it a month? Is it a year? Does it vary by case? What can you tell us about that?
So it does vary based on the type of order, but most are, up to 2 years. They can be, there are provisions that allow someone to petition for them to be terminated early or to be amended in terms of what they specify. They could be extended in some circumstances. There are some states that have a provision and a process to get more permanent orders, but you really have to meet a specific set of circumstances for those. And although they're sometimes referred to as permanent or lifetime, very few actually allow them to be for life. And all of them allow for a petition for the court to revisit the terms or to terminate early. So mostly a couple of years.
And I know you didn't ask this, Elizabeth, but we should also mention that there's full faith and credit with protection orders. So even if you have one in New York and you move to California to try and start over or escape or something like that, it's still fully enforceable in another state, which is why they're also a useful tool.
Thank you. That's an important clarification. So I'm going to ask Michelle McLean to ask the next question. Michelle is a senior at John Jay and a member of our Pre-Law Scholars Program. She is majoring in Law and Society and minoring in Political Science. So Michelle, please go ahead.
Hi, good afternoon, everyone. My question is directed at Dr. Mack and Mr. Millhiser. So the question is, given the fact that the Supreme Court has significant influence over social and criminal justice matters, as well as civil rights, how can we as students monitor or follow its activity? And in addition to that, are there any other cases that are on the course docket that we should be mindful of?
I'm happy to.
Go ahead, Ian, if you want to jump in first, go ahead.
Yeah, I mean, SCOTUS blog is wonderful. Read my stuff at Vox. There's lots of reporters out there who are covering the court if you're just looking for a way to monitor it. In terms of what's coming down the pipe, I mean, this is going to be an enormous goddamn term. Setting aside the Trump cases, which are going to be their own thing, I think that there are two big themes that are likely to emerge from this term. So one is the court is very interested in concentrating as much power as it can within itself. I already said that my prediction is the outcome of Rahimi, and they'll say something about dangerous persons and they'll say something about history and tradition, but the actual holding will be that you need 2 of John Brett Namey to uphold a gun law, and whatever 2 of those 3 think, that's what our gun policy is going to be. They are going to become the gun policymakers in the United States. The 2 biggest cases that are being argued this term, bigger than Rahimi, are 2 cases that were just argued called Loper Bright and Relentless. These are cases that involve, so the executive branch of government, federal agencies have a huge amount of power to issue binding regulations. Congress has given them this power. They have traditionally had the last word on most policy decisions that are within their purview. And this touches on everything, any issue you care about. It touches upon it. What is overtime pay? What is your cable bill going to be? And in some places, does your doctor have to provide you with gender affirming care? Like whatever issue you care about, this issue is going to be touched on by federal regulations. And what the court seems to be poised to do in the Relentless and Loper Bright cases and say, rather than the executive branch, which is led by an elected official having the final word on this, it said the final word on all federal regulatory decisions shall be the Supreme Court of the United States with its 6-3 Republican supermajority. So the first phenomenon we're seeing is a concentration of power within the Supreme Court. The second thing we're seeing, and Rahimi is part of this, is I mentioned this comes out of the Fifth Circuit. This isn't even the wackiest opinion to come out of the Fifth Circuit. That is before the Supreme Court this term. They struck down an entire federal agency, the Fifth Circuit did, the Consumer Financial Protection Bureau, in an opinion that if it was taken seriously by the Supreme Court would probably cause a second Great Depression. There is the Meavy-Prestone case, whether judges have the power to ban drugs that they don't like. There's a case that the Supreme Court's likely to take soon called McKesson, which effectively eliminated the First Amendment right to organize a protest. I mean, just crazy stuff coming out of the Fifth Circuit. And I think the Supreme Court is going to reverse in nearly all of these decisions, including the Rahimi decision. So what is going to be the theme that emerges from this term? Like what will we be saying about what happened? One is that the justices want to control everything. But the second thing is just because they want to control everything doesn't mean that they're going to really reach the most maximally right-wing outcome in every single case. The Fifth Circuit's doing that, but they seem to have staked out a ground that, while still very, very conservative, is more sensible than what the biggest lunatics in the judiciary want to do.
So I'll jump in. So now more than ever, like I wish I could have been a Supreme Court geek now when I was a kid, more so than I was, back in, when constitutional law was, still on chisels and tablets, right? The thing I would argue is just get involved, start reading. The best thing about social media is that there are so many outlets for you to read. Ian's articles are readily available online via Vox, right? You find sources that you find credible and interesting, and you start listening to those. I was talking to Ms. Broccoli the other day, and we were listening to oral arguments for the Rahimi case, right, on the commute. Right now, more than ever, you're able to access so many things about the Supreme Court that's so interesting and allows you to engage. But the other part is that the importance of being engaged and finding information about the Supreme Court is it informs your vote. Vote like your life matters on, right? Vote like everything depends upon it, because over the next couple of years, you're going to see retirements in the Supreme Court, and the president that you put in replaces those people. So that's how I would suggest you get engaged, is just start reading. It's not hard. That there are great reporters out there like Ian that can actually give you the information that you're needing. You could also take classes from awesome professors, right, at John Jay College that can help you kind of be engaged. And then as for cases, I would say they're all important on some level, but the ones to really look out for are the ones that impact your rights. So the voting rights cases, the gun rights cases, right, the abortion cases, those types of cases are really easy, and we won't get into details because I want everyone else to speak, but the Trump ones are really easy to focus on, right? But the ones that actually impact your life are the ones like Rahimi. That this is going to have major consequences for every potential person who enters into a relationship in the future.
Thank you so much, Dr. Mack and Mr. Millhiser.
All right, Giovanni Love will ask the next question. Giovanni is a member of our Pre-Law Scholars Program and a junior at John Jay who is studying philosophy. Giovanni, go ahead, and then after the panelists respond to Giovanni's question, we'll open it up to Q&A.
Thank you, Ms. Broccoli. I would also like to tag on to that voting, that it's really important to vote locally, not just in an election every 4 years, but voting in every single election. My question is for all of you, actually. How can our future advocates at John Jay and elsewhere advocate for justice, for justice work to protect victims of domestic violence? What can we do?
Well, I can start if no one else wants to jump in, but just a couple of things, that come to mind immediately is no matter what field you go into or are in, assume that there are survivors of intimate partner violence in every space that you're in, because it's more than likely that that's true. And listen to survivors' own assessment of their safety and safety risks because they know best. And also understand that there is no one-size-fits-all approach to addressing intimate partner violence. It looks different for different people. Everyone's needs are different to reach safety and stay safe. And so we need to be informed in how we approach this by the variety of perspectives that exist, so that every person, no matter what community they come from or what their needs are, has the ability to access services and safety that match what their needs are.
And I'll just at the end of that, where one of the things I learned when I was really starting out in law enforcement was a concept that a lot of people feel or don't understand as well. If this abuse keeps occurring, why does the person stay? And so what we've been, talking about in the gender-based violence field for a very long time is it doesn't matter, for you, the person that's asking the question, why the person stays. You're supposed to meet the person kind of where they're at. And one of the most dangerous times in a survivor of domestic violence life is when they do decide to leave or they try and leave. And there has to be a lot of planning and a lot of implementation or some stopping and starting. Takes on average, I don't think the statistic has changed, but takes on average 7 real, thinking about or actual attempts to leave a domestic violence scenario. Because when they started that relationship, it did not start out, emotionally abusive, physically controlling, physically violent. It was someone that they, either fell in love with or was a member of a family, and that was your family unit and what you're seeing. So what I train people on is to be the best advocate that you can be is meeting the person where they're at, not telling them what to do, but listening to what their needs are that maybe either you can help supplement with or refer to services, or just be an emotional support to them as they try and navigate that path of safely leaving.
Sorry, I'll add to that from my own experience. I was a prosecutor in the Bronx for 7 years, and I specialized in intimate partner violence cases. And when you work within systems, sometimes we have these preconceived notions of what justice looks like, and should look like. And I had an unexpectedly sort of what ended up being a profound moment for me professionally when I asked a survivor, what does justice look like to you in this case? And her response was not what I would expect in the way the system is constructed and what I, was taught my role was. And it was very simple and it was achievable, but it didn't look like maybe, quote, success for what, my role was. And it changed how I practiced. It changed the course of my career, asking that question. And then I asked it every single time. So I think not having those preconceived notions of what justice looks like or what, what protecting someone looks like.
So I'll jump in real quick just to reiterate a theme that several of us have brought up, which is that, again, all of this is happening. The only reason we're having this conversation right now is because of the result of the 2016 election. Every single Republican on the Supreme Court was in the majority in the Bruen decision. Every single Democrat was in dissent. At the oral argument in Rahimi, the one justice who was most eager to overrule Bruen, she brought it up over and over and over again, was Ketanji Brown Jackson, the only Biden appointee on the Supreme Court. So The immediate thing that's coming up that's going to have obviously a huge effect on all policy questions, but specifically on the question of whether or not dangerous people are allowed to own firearms. If you want more justices who are going to do what the Fifth Circuit does, vote for Donald Trump. And if you want more justices like Ketanji Brown Jackson, vote for Joe Biden and go to wherever his nearest campaign place is and volunteer for him.
I'll jump in with a similar big one, but I think it goes back to the political science answer, which is vote, right? But vote locally, right? So New York is courts, that kind of experimentation with greater accountability only comes from the local level and the state level, right? The federal government hasn't adopted that approach yet. And having that accountability, like supporting offices like the Office for Justice Initiatives, who pushes for these problem-solving courts, is key, but that only comes by voting in judges in New York that will actually actively push for that change, voting in DAs who will hold greater accountability and provide for victim safety, right? Those are the things you should do. And also be active, right? Take on the ownership of learning more, right? Take on the ownership of actually understanding where everyone's coming from. I want to circle back to one thing, which is this idea of the Fifth Circuit. It's actually the law that's really problematic. I know the Fifth Circuit's really bad, right? But the panel that decided Rahimi, that struck down 922, actually supported 922 in the original case. Before Bruen was decided, they decided that no, the government has the ability to regulate based on the social kind of safety created, right, by preventing domestic violence abusers, right, from holding guns. Bruen flipped that, and the same panel flipped their decision, right? So you have to put in judges to do good law too, because good law can also bind judges despite their ideologies.
Thank you all. So we have some time for questions. We already have a few questions that were submitted. If you have a question that you'd like to ask one or all of the panelists, please put it in the question and answer. I'm seeing some great questions. Somebody asks, if the Supreme Court rules the firearm restrictions as constitutional in Rahimi, will that reinstate these restrictions for Texas, Louisiana, and Mississippi?
In that Fifth Circuit, yes.
We have somebody says that she is a survivor, excuse me, of domestic violence with a restraining order, and a rape survivor, is asking whether the statute of limitations will be increased for rape as it was changed for child sexual cases.
So there are statute of limitations on both criminal charges, and then there's separate statute of limitations to apply to bringing civil lawsuits. So there have been some changes on both in recent years in New York. I'm not sure if there's any bills pending currently. I think maybe what the question is referring to is the Child Abuse Survivors Act, which opened a look-back window to allow for civil lawsuits for child sexual abuse. And then there was a similar look-back window that opened for adult survivors. May still be open actually, but I can't remember when it's closing. But can definitely monitor bills that are pending, because there are sort of every session some bills introduced related to this usually. Another good place to maybe seek information specific to domestic violence and sexual assault bills in New York is to look to the New York State Coalition, because they monitor bills that relate to survivors, and they're a good source.
Thank you. We have another question. Someone asked, how do you all as practitioners and educators hold and balance these legal approaches to domestic violence response prevention alongside non-legal approaches like economic gender justice policy? The person feels like the Supreme Court news can suck all of the air out of the room from other ways of thinking and talking about justice.
Prior to my role, currently, I was with a national gender equality organization that focused on a broad range of women's rights issues. And one way that we approach the work is by simultaneously using impact litigation strategies, with policy advocacy strategies, and education and training strategies. And so there were times that we were, advocating for a policy, and then litigating under that policy, or litigating to expose a loophole in policy that then we could advocate to close. The education component was really important, because a lot of times we actually have decent policy in place. People don't know how to use it or don't know what rights they have. And so, reaching different communities and other practitioners to educate was really important. So, when sort of litigation wasn't a successful option for lots of reasons, like maybe makeup of courts and unlikelihood, we could turn to, building up greater awareness and how to use the rights that exist, or administrative advocacy to get better guidance and regulation on existing policy. So there's a wide range of strategies that you can take, and some of it is just using what we do have in place in different ways.
Thank you. So we have one more question from Nick Mills. Most of the Supreme Court cases involve carefully selected litigants. Any theory of why this offender's case was selected?
I guess I can take that one. I mean,
Sure.
the short answer to that is that the Supreme Court almost always takes any case where a lower appeals court struck down a federal law. The job of the Supreme Court is to maintain the uniformity of federal law. And so if one court strikes it down, the Supreme Court needs to get involved, or else the law is going to be different in Texas than it is in Michigan. So that's the short answer. That said, I mean, it's not the justices who, if anything, the Biden administration made sure that this would be the next case that the Supreme Court, the next Second Amendment case the Supreme Court had heard after Bruin. So there are actually two cases. There is this Bruin case, there's this Rahimi case that involves the worst person in the universe as the defendant. There was also a case out of the Third Circuit where the court struck down, like the facts of this case is, I believe that the gentleman was charged with being a felon in possession of a firearm. The felony that he was convicted of was like, he accidentally committed welfare fraud many, many years ago because his wife filled out a form that had some false statements about his income in it, and he signed the form without reviewing it, and so he didn't realize he was defrauding the government and got a felony conviction. So this is the most sympathetic possible individual who, in that case, and like the question in that case is whether that individual can constitutionally be disqualified from having a gun. And the Solicitor General was very careful about making sure that they got the petition to ask the Supreme Court to hear the Rahimi case to the justices as fast as possible, while at the same time, like, dragging their feet on asking the justices to hear this other case. It's called the Range case. They're going to hear Range eventually, but they're going to hear it after they decide Rahimi. That's just, smart litigation strategy. After a train wreck like Bruin, you want the next case that it comes to the justices to be something that highlights how much of a train wreck it is, and does it encourage the justices to entrench the terrible Bruin ruling further by bringing a case with a very sympathetic individual. But like, the answer to why this case came up the way that it came up next is because these two cases were decided in very close proximity to each other. And this, Elizabeth Prologer, the Solicitor General, I think is the best appellate advocate in the country. And she correctly realized that the right litigation strategy was to make sure that the justices heard the one involving this absurdly dangerous person who's like a comic book supervillain, and not the one involving, the person who accidentally signed the wrong form.
Thank you.
I'll also throw
sorry,
in
go
there,
ahead.
though, is that what we're called, the federal government did the right thing here. But even if the situation was reversed, right, and let's say the United States won at the lower courts, the conservative right, in terms of its litigation movement, has become emboldened, right, by a 6-3 majority on the Supreme Court. That you see it with Voting Rights Act, with blatant violations of legislatures willing to gerrymander districts. They've been emboldened by a new Supreme Court that is a much more firm plant in conservatism, right, that they kind of almost don't care about the strategy because they know they might win if they vote straight on ideology. And so therefore, they're just going to keep on appealing cases. And at some point, based on how the Supreme Court decides cases, right, some of these will just pop up and you'll just shrug your shoulders and go, wow, that was a really bad choice. And that might happen more and more now that there's 6 conservatives versus 5.
Thank you. So this brings us to the end of our program today. Thank you so much to Jennifer Becker, Ian Millhiser, Maxwell Mack, and Jennifer Wendell for speaking with us today about this important topic. Thank you to Michelle McLean and Giovanni Love for your questions today. Thank you to the Office of External Affairs for organizing this program, Mindy Bockstein, Jennifer Lorenzo, and Alexa Barisano. And thank you to our audience today for joining us and for your questions. And we hope that everyone has a great rest of your day. The video recording of today's program will be available on YouTube in a few days. Thank you, everyone.